Hey there! Thanks for tuning in to the Anarcho podcast, where we are reading Against Intellectual Property by Stefan Kinsella. This is the second episode, and in this episode we will be covering the Libertarian Perspectives on intellectual property. Before we start, let's quickly recap what we learned in the first episode. Stefan Kinsella gave us a summary of intellectual property law as it is currently in the United States. We learned there are some differences between the various kinds of intellectual property. But to begin with, he made this distinction between tangible property rights, so things that we can touch, like houses, chairs, etc., and now this intangible kind of property rights concerning ideas. And in the US, we currently have four basic kinds of intellectual property law, namely copyrights, so the right to copy a novel. And we learned that this regards kind of like the arrangement of words that the author has thought up in their mind, and they are supposedly the only ones who have the right to copy that arrangement of words onto books, for example. Then we have patents that are concerning inventions, devices, processes, and this patent right gives the holder of the patent the right to go to the government and exclude others from also using their invention, device, or process. Thirdly, we have trade secrets. This would be the formula for Coca-Cola, for example. And those are not primarily kept by the government and more contracted between the employer and employee. And last but not least, we have trademarks. So this is regarding the recognizability of a brand. So for example, the iconic Coca-Cola font. So with this knowledge in our minds, this is really important because we want to have clear thoughts on intellectual property. We can now move on to the libertarian perspectives on intellectual property. Libertarian perspectives on IP. The spectrum. Libertarian views on IP range from complete support of the fullest gamut of IP imaginable to outright opposition to IP rights. Most of the debate about IP concerns patent and copyright, as discussed below. Trademark and trade secret are less problematic. Therefore, this article focuses primarily on the legitimacy of patent and copyright. So with our extensive background knowledge of the landscape of the intellectual property law in the United States, we can come with some nuance to this discussion. And I think it's really important that we kind of single out the most offensive kinds, which will be patent and copyright. All right. Pro-IP arguments may be divided into natural rights and utilitarian arguments. Libertarian IP advocates tend to adopt the former justification. For example, natural rights, or at least not explicitly utilitarian, libertarian proponents of IP include, from more to less extreme, Galambos, Schulman, and Rand. So Ayn Rand would be the least extreme of these three. And before I continue reading here, I think it's maybe for the people who are not yet so well versed in political philosophy, we have these two camps, I would argue, that are using different arguments to justify property rights in general. And so one is the deontological camp, or as it's called here, the natural rights camp. And the other is called the utilitarian camp. The natural rights camp, the deontological camp, is arguing like You have certain rights because of your nature as a human being, because of your faculty for reason, that you use reason as your primary modus operandi to navigate the world and to sustain your life. And the utilitarian argument, utilitarian means like the greatest good for the greatest amount of people. And those are just like basically consequentially arguing, well, if we do have property rights, this leads to the greatest good for the greatest amount of people. And while they may arrive at the same conclusion, it's very different paths of argument. That, utilitarian always has to kind of think about what the consequences of a given legal framework would be, and if that would benefit actually the greatest amount of people. Where the deontological camp is less concerned with that, and they say, I mean, you are just like, these are your natural rights. It doesn't matter if it leads to the good of the other people. Those are your rights. And so just to keep that in the background, and maybe as a funny aside note, what usually is the argument put forward by utilitarians is the trolley example, that you have a train barreling down some tracks and there is a divide coming up. Currently, the train would run over 5 people, but you are in the unique position to flip a switch and then let the train run a different rail where it only runs over 1 person. And now the question is it moral for you to flip the switch? Is it immoral for you to do nothing? And so on and so forth. And this is a very boiled down example of having a greater amount of good, because supposedly if 5 people are saved or a greater number of people are saved, then this is better for society than if they die in opposition to just 1. All right. Among precursors to modern libertarians, Spooner and Spencer both advocate IP on moral and natural grounds. According to the natural rights view of IP held by some libertarians, creations of the mind are entitled to protection just as tangible property is. Both are the product of one's labor and one's mind. Because one owns one's labor, one has a natural right to the fruit of one's labor. Under this view, just as one has a right to the crops one plants, so one has a right to the idea one generates and the art one produces. So basically trying to follow the same logic that we have for the homesteading principle. Well, if I can till my soil, plant some crops and harvest them and they are mine, then so too would be the ideas that tumble out of my brain. This theory depends on the notion that one owns one's body and labor, and therefore its fruits, including intellectual creations. An individual creates a sonnet, a song, a sculpture, by employing his own labor and body. He is thus entitled to own these creations because they result from other things he owns. So Rothbard in the Ethics of Liberty, I think, gives this example of a sculptor who goes to the beach or whatever, unowned natural resources, digs up some clay, thereby homesteading the clay and making it his own, and then proceeding to sculpt a thing out of the clay, a sculpture. And since he owns the clay beforehand, he now owns also the sculpture. And similarly, this argument follows that, well, you own your mind, so would follow that you also own your ideas, the creations of your mind. There are also utilitarian pro-IP arguments. Federal Judge Richard Posner is one prominent utilitarian, although not libertarian, IP advocate. Among libertarians, anarchist David Friedman analyzes and appears to endorse IP on law and economics grounds, a utilitarian institutional framework. The utilitarian argument presupposes that we should choose laws and policies that maximize wealth or utility. With respect to copyright and patent, the idea is that more artistic and inventive innovations correspond with or leads to more wealth. Public goods and free rider effects reduce the amount of such wealth below its optimal level, i.e., lower than the level we would achieve if there were adequate IP laws on the books. Thus, wealth is optimized, or at least increased, by granting copyright and patent monopolies that encourage authors and inventors to innovate. And I think this is the classic argument that I usually encounter when arguing with people about intellectual property. In general, this whole strain of utilitarianism is very strong in our modern world, unfortunately so, because I think it leads to heinous conclusions about what would be moral and what wouldn't, but that's beside the point here. I think, but we can summarize it like, well, if I can get a patent on my invention, then I'm more likely to slave away in my basement for years on end trying to find that perfect invention. So because I know once I have it, it will be mine. It will be a monopoly granted by the state. And if I were not to have it, why would I invent so much time in research and development if the next person could just come along, take a good long look at my invention and then proceed to copy it? Like, the whole incentive for me would fall away. Hence, I wouldn't even bother inventing things, and hence we would have stifled innovation. On the other hand, there is a long tradition of opposition to patent and copyright. More modern opponents include Rothbard, McElroy, Palmer, LePage, Burkhardt, I'm sorry if I'm butchering these names, and myself. Benjamin Tucker also vigorously opposed IP in a debate in the 19th century, individualist anarchist periodical Liberty. These commenters point out the many problems with conventional utilitarian and natural rights arguments given to justify IP. These and other shortcomings of standard pro-IP arguments are surveyed below. So just to recap this section, I think this is really good put forward by Kinsella, that he tries to steelman the arguments of the opposition. I mean, obviously, it's the opposition because his book is titled Against Intellectual Property and not in defense of intellectual property. But when he spells out the arguments, I think he does a great job of not arguing immediately against it, just trying to put forth the argument as strongly as he can in defense of intellectual property. Also, just as an aside note, because it comes to my mind, I used to be a really big fan of Ayn Rand, still am to some regard, but she really had a very strong stance on intellectual property, and this is also some disagreement I have with her philosophy nowadays. Anyhow, let's continue with the utilitarian defenses of IP. Advocates of IP often justify it on utilitarian grounds. Utilitarians hold that the end of encouraging more innovation and creativity justifies the seemingly immoral means of restricting the freedom of individuals to use their physical property as they see fit. But there are three fundamental problems with justifying any right or law on strictly utilitarian grounds. Interesting here that most utilitarians at least concede the point that, well, yeah, of course, we recognize that IP means that you cannot use your own property as you would see fit. Like, if you happen to walk by your neighbor's garage and he just rolls out this great invention that he had, and you take a good long look at it and then proceed to your garage and copy it, we recognize that technically this is kind of your property and you should be allowed to do with it what you want. But if you were allowed to do that, then the entire society would suffer because your neighbor wouldn't bother inventing the great invention in the first place. All right. First, let's suppose that wealth or utility could be maximized by adopting certain legal rules. The size of the pie is increased. Even then, this does not show that these rules are justified. For example, one could argue that net utility is enhanced by redistributing half of the wealth of society's richest 1% to its poorest 10%. But even if stealing some of A's property and giving it to B increases B's welfare more than it diminishes A's, if such a comparison could somehow be made, this does not establish that the theft of A's property is justified. Wealth maximization is not the goal of law. Rather, the goal is justice, giving each man his due. Even if overall wealth is increased due to IP laws, it does not follow that this allegedly desirable result justifies the unethical violation of some individuals' rights to use their own property as they see fit. And here we really, do you recognize this? Do you recognize this argument of tax the rich and just redistribute the wealth of Elon Musk and Jeff Bezos to the poor people of the world, and then we would all be so much happier? I mean, this is made countless times in our modern world, but here the deontological side of Kinsella shines through, namely that it could well be that that the welfare is increased, but you have just committed a crime. You have stolen A's property, and this is it is never justified, no matter how noble your intentions are, right? Because it could mean that I rob somebody in the street and steal their wallet and proceed to give it to charity. Would that then justify the theft? Well, I don't think so. And this is exactly the divide between utilitarians and deontological or natural rights thinking. If you are on the side of the natural rights, you believe that these violations of property rights, of rights in general, are always immoral. And if you are a utilitarian, you could be convinced, right? If you can make the argument convincingly that actually robbing Elon of his wealth and redistributing it to other people is a net benefit, well, then we could argue and we can talk about this. So this is what I was referring to earlier when I said that utilitarianism can lead to these heinous scenarios where, well, it's actually a society net benefit if we just take your kidney because, we could redistribute it. And it's really immoral for you to actually oppose this taking of your kidney. And of course, I'm going into extremes here, but I think with these philosophical questions, the extreme is usually where we can make the argument, shine through the most. In addition to ethical problems, utilitarianism is not coherent. It necessarily involves making illegitimate interpersonal utility comparison, as when the cost of IP laws are subtracted from the benefits to determine whether such laws are a net benefit. But not all values have a market price. In fact, none of them do. Mises showed that even for goods that have a market price, the price does not serve as a measure of the goods' value. So, if you consider yourself an Austrian economist or a follower of the school of Austrian economics, then you believe in the subjective value theory, namely that things in the world never have intrinsic value. Such a thing doesn't exist. Value is always in the eye of the beholder. So you looking at a piece of bread, you have some estimation of value of that piece in your head, and me looking at that piece of bread, I have some different evaluation of that piece of bread in my head. And these values are hidden. You cannot show them to the world. And even if you were to state, oh, I value this piece of bread at 1,000 units of utility, whatever that means, you could be lying. Like, how would I actually know that you're telling the truth? And the brilliant insight of Austrian economics is that we don't have to know what your actual valuation of a given good is. As long as you voluntarily exchange it with some other party, with an agreed upon price, we can say that, okay, this price for the piece of bread was 1 unit, for example. So we can say with certainty that the valuation of that piece of bread for the seller was less than 1, and for the buyer it was more than 1, because the buyer was willing to give up 1 unit of whatever monetary commodity, and the seller was willing to give up his piece of bread for that 1 unit of monetary commodity. And the fallacy of utilitarianism is really to try to bring this math into it. Yeah, to have these utility functions where we can sketch out, oh, okay, if we now increase the utility of A by 2, then it is a net benefit for society. But this is really a nonsensical exercise. We cannot compare these value scales among different people. So in the economic terms, we are also talking about ordinal values. So you can have a hierarchy of values where you say, okay, this is my number 1 value, for example, my own life. And this is my number 2 value. So you have a ranking. And what they are trying to do is these cardinal valuations where you have person A, person B, and you can compare them between the two. But this is really not possible, as the Austrian School of Economics has established. Finally, even if we set aside the problem of interpersonal utility comparisons and the justice of redistribution, and we plow ahead employing standard utilitarian measurement techniques, it is not at all clear that IP laws lead to any change, either an increase or decrease in overall wealth. It is debatable whether copyrights and patents really are necessary to encourage the production of creative works and inventions, or that the incremental gains in innovation outweigh the immense cost of an IP system. Econometric studies do not conclusively show net gains in wealth. Perhaps there would even be more innovation if there were no patent laws. Maybe more money for research and development would be available if it were not being spent on patents and lawsuits. It is possible that companies would have an even greater incentive to innovate if they could not rely on a near 20-year monopoly. And I think, so he begins, Kinsella begins to demolish the arguments for intellectual property on the libertarian spectrum here. And I think this argument that he put forward, if the last two didn't convince you yet, is really strong. So he's saying, so let's take that aside with the redistribution, stealing from A and giving to B, and let's leave aside the comparing utilities between A and B, all of that. Just on the face of copyrights and patents, it's not clear that if we have these legal frameworks to protect intellectual property, that this is actually a net benefit for innovation. Because consider the millions and billions of dollars that are spent on keeping one's intellectual property. There was this fight, I remember, between, I think, Apple and Samsung about having rounded corners in their smartphones. And this is all money spent in court where, in the end, the consumer gains nothing out of this. Yeah, so it's not entirely self-evident that just because you have this patent and copyright system that this benefits the consumer in the end, because these millions and billions could also be spent on research and development. And maybe if you cannot rely on this government monopoly to like lay down on your cushions and say, ha, now I invented something, now I have a patent, yeah, maybe you're driven to innovate more, to keep pushing, yeah, because you especially cannot rest on the Lorbeeren and laureates, I think, that you have accumulated over the years. So it's just not clear, and it's not self-evident that the patents and copyrights actually do lead to more innovation and benefit the consumer in the end. There are undoubtedly costs of the patent system. As noted, patents can be obtained only for practical applications of ideas, but not for more abstract or theoretical ideas. This skews resources away from theoretical research and development. It is not clear that society is better off with relatively more practical invention and relatively less theoretical research and development. Additionally, many inventions are patented for defensive reasons, including in patent lawyers' salaries and patent office fees. This large overhead would be unnecessary if there were no patents. In the absence of patent law, for example, companies would not spend money obtaining or defending against such ridiculous patents as those in the appendix. It simply has not been shown that IP leads to net gains in wealth. But should not those who advocate the use of force against others' property have to satisfy a burden of proof? So, yeah, who is the burden of proof on? I guess the person who is trying to rob you at gunpoint or trying to prevent you at gunpoint from using your own property the way you see fit. And if they cannot have a convincing argument, as we just seen that they don't, then, well, maybe you shouldn't be so quick to pull the trigger. And yeah, I think really interesting. If we just consider, I mean, I'm not in the world of a patent lawyer, but I can try to imagine the legal effort it takes for, let's say, an inventor to go this entire legal procedure, to have their inventions filed just because out of defensive reasons. Yeah, if you don't file the patent, some other schmuck may come along and file the patent in your stead. And then they have the fist of the state behind them to prevent you as the original inventor to actually use your own invention. So you are kind of forced into this legal system and you have to spend resources there, where that's really not your expertise. So it's not entirely clear that the patent system is a net benefit. We must remember that when we advocate certain rights and laws and inquire into their legitimacy, we are inquiring into the legitimacy and ethics of the use of force. To ask whether a law should be enacted or exist is to ask, is it proper to use force against certain people in certain circumstances? It is no wonder that this question is not really addressed by analysis of wealth maximization. Utilitarian analysis is thoroughly confused and bankrupt. Talk about increasing the size of the pie is methodologically flawed. There is no clear evidence that the pie increases with IP rights. Further, pie growth does not justify the use of force against the otherwise legitimate property of others. For these reasons, utilitarian IP defenses are unpersuasive. Wow. So really taking the hammer to the utilitarian argument there. And I think I want to drive this point home. The use of force. When is it legitimate or when is it not? And this is really also something Rothbard in The Ethics of Liberty hammered home. The entire point of political philosophy is to ask this question. When, under which circumstances is it justified to employ the use of force? Because there is an extreme here, right? We could say we are a pacifist. We always object to the use of force. And Rothbard gives this example that always stayed in my mind. That would mean going to the logical conclusion that, say you come home and you find your sister being raped, you couldn't do anything to stop the rapist from it, right? You could there stand and say, well, maybe you shouldn't do this, try to convince him, but really you cannot use force to stop them. And So this is the one extreme, the pacifist, and the other extreme would be the might makes right. You just bash everybody over the head, you want to take something from, and you take it from them. And both extremes are not really feasible. So the question is, under which circumstances is the use of force justified? And this is exactly what Rothbard in The Ethics of Liberty spells out. He tries to wrestle with according to the principles established by the Homestead Principle and tries to draw out the logical conclusions. And when we talk about laws and government, force is somehow a little bit removed, right? When you tell people, hey, taxation is theft, conscription is slavery, they are hesitant to believe it because, after all, it's not like the mob who show up at your house demanding protection money. I mean, it's kind of is like that. There are just a few steps in between. You know, like this quote from Rick and Morty, that just sounds like slavery with a few intermediate steps. And this is exactly the point, right? You try to formalize this use of force that, hey, I'm just the judge, I'm just putting my hammer down, and hey, I'm just the police officer, I'm just doing my work, and hey, I'm just the jail warden who is doing my work, like just doing my job, sir. And so this removal or this splitting of the responsibility allows people to justify whatever they are doing in their mind and, not feel so evil. But when we take a step back, when we look at the bigger picture, this is exactly what laws are doing. Like they are saying, hey, this is an action which can be responded with by the use of force. So it's not really innocent when we talk about intellectual property. We are talking about legitimizing the use of force against people who are just using their own legitimate property, as we have established in the Crusoe economy and the Ethics of Liberty. Some problems with natural rights. So now we move to the natural rights argument and away from the utilitarian. For me personally, I'm satisfied. I'm not a utilitarian myself, so naturally I'm a little bit of a pushover when it comes to these arguments, but I think Kinsella put forward some really strong arguments that maybe even if you are a utilitarian yourself, then you may be convinced by those arguments. That just on the basis of the consequentialist approach, that it's not really clear that actually having this idea of patents and copyrights does lead to a greater benefit for society. Other libertarian proponents of IP argue that certain ideas deserve protection as property rights because they are created. Rand, so Ayn Rand, supported patents and copyrights as the legal implementation of the base of all property rights, a man's right to the product of his own mind. For Rand, IP rights are, in a sense, the reward for productive work. It is only fair that a creator reap the benefits of others using his creation. For this reason, in part, she opposes perpetual patent and copyright, because future unborn heirs of the original creator are not themselves responsible for the creation of their ancestors' work. And this is what I was alluding to earlier. Ayn Rand really has a strong opinion on property rights. And I mean, she's big when it comes to anything concerning the mind, right? Reason and the mind are central to objectivism, Ayn Rand's philosophy. And she herself was an author writing The Fountainhead, Atlas Shrugged, many other books. And of course, she felt like she owned this in some regard. Yeah, that she had the right to this idea that she created. And I think it's important to note that created here is printed in italic, because I think we may circle back to that in a little bit. One problem with the creation-based approach is that it almost invariably protects only certain types of creations. Unless, that is, every single useful idea one comes up with is subject to ownership. More on this below. But the distinction between the protectable and the unprotectable is necessarily arbitrary. For example, philosophical or mathematical or scientific truths cannot be protected under current law on the grounds that commerce and social intercourse would grind to a halt, where every new phrase, philosophical truth, and the like considered the exclusive property of its creator. For this reason, patents can only be obtained only for so-called practical applications of ideas, but not for more abstract or theoretical ideas. Rand agrees with this disparate treatment in attempting to distinguish between an unpatentable discovery and a patentable invention. She argues that a scientific or philosophical discovery, which identifies a law of nature, a principle or a fact of reality not previously known, is not created by the discoverer. But the distinction between creation and discovery is not clear-cut or rigorous, nor is it clear why such a distinction, even if clear, is ethically relevant in defining property rights. No one creates matter. They just manipulate and grapple with it according to physical laws. In this sense, no one really creates anything. They merely rearrange matter into new arrangements and patterns. An engineer who invents a new mousetrap has rearranged existing parts to provide a function not previously performed. Others who learn of this new arrangement can now also make an improved mousetrap. Yet the mousetrap merely follows laws of nature. The inventor did not invent the matter out of which the mousetrap is made, nor the facts and laws exploited to make them. And I think, wow, this is also a really strong argument in my opinion, that this creation myth, that it's easy to talk about, oh yeah, I've created a novel, I created a better mousetrap, but when we really dissect every word, and I think in the legal context we do have to do that, you didn't create it. You took some other matter, some other ideas and synthesized it, or like Kinsella said, rearranged it to create something more useful for you in the case of a better mousetrap. And yeah, no human can create matter. We all just take the matter that is in the universe and we can transform it, making it more useful. And if that matter was previously unowned natural resources, we thereby acquire ownership and property rights over that matter. So this creation argument, and I mean, it's a clever attempt from Ayn Rand to distinguish between these discoveries and inventions. It's an attempt, but we see that it kind of falls flat, and the distinction really does not hold up when we examine it closely. Similarly, Einstein's discovery of the relation E equals mc square, once known by others, allows them to manipulate matter in a more efficient way. Without Einstein's or the inventor's efforts, others would have been ignorant of certain causal laws, of ways matter can be manipulated and utilized. Both the inventor and the theoretical scientist engage in creative mental effort to produce useful data, new ideas. Yet, one is rewarded and the other is not. In one recent case, the inventor of a new way to calculate a number representing the shortest path between 2 points, an extremely useful technique, was not given patent protection because it was merely a mathematical algorithm. But it is arbitrary and unfair to reward more practical inventors and entertainment providers, such as the engineer and songwriter, and to leave more theoretical science and math researchers and philosophers unrewarded. The distinction is inherently vague, arbitrary, and unjust. When it comes to, and this is me speaking now, when it comes to natural philosophy and natural rights philosophy, we really have to be careful with this arbitrary differentiation, because we are in this realm of, okay, what is the nature of things. And to make these arbitrary distinctions really can lead us astray and lead to all kinds of curious cases. And for example, what comes to my mind here is how brilliantly Rothbard followed his own reasoning in the Ethics of Liberty. So the argument is that human beings are self-owners. They own their own body. And the question now is, well, when is that the case? When does a child become a adult, a full self-owner? And when can they choose what choices they make in life? If they want to drink beer, if they want to gamble, and whatever. And in modern society, we have some ages, 18, 21. This is when you are a full adult. And Rothbard rejects this as arbitrary. And rightfully so. Because it's just a number, and maybe some person at the age of 18 is fully developed and some other is a child really. So what should the correct answer be then? And what I really appreciate about Rothbard is that he goes and follows his own principle, which in this case would mean that, hey, the child actually is always a self-owner. They already own themselves. The question is now just when do they take the reins? When do they make their own decisions? And this is dependent on themselves. So when the child lives with the parents in the parents' house, in the parents' property, the parents can make the rules and can say, hey, in German, it's kind of like a saying, as long as you stretch your feet under my table, you follow my rules. This is what the stern father would say to the rebellious youngster. And it really holds up when we follow this principle of homesteading, because it is the parents' home or the father's home or whatever. And they make the rules. And when they say our curfew is at 10 and you're not home at 10, they technically have the right to close the door and don't let the child in. And similarly, the child, or vice versa, the child has the right to say, well, I'm not going to stretch my feet under your table, father. I'm going to venture out into the world and find my own luck. And then they pack their bags and they are on their way. And in the philosophy of Rothbard, this means that the child has now taken the full ownership of their own body and they can really make their own decision and choices. So this is what I mean by these arbitrary distinctions, that if we have these principles in natural philosophy that we try to follow, we have to follow them completely. And we have to arrive at whatever conclusion we arrive at. So this distinction between it's just a theoretical discovery and, oh no, this is actually a practical invention is really arbitrary, and it tends to favor one kind of ingenuity over another. I guess if you discover something, it's not really ingenuity because it doesn't have to do with engineering, but I hope you try to get the point that Kinsella is making here. Moreover, adopting a limited term for IP rights as opposed to a perpetual right also requires arbitrary rules. For example, patents last for 20 years from the filing date, while copyrights last, in the case of individual authors, for 70 years, past the author's date. No one can seriously maintain that 19 years for a patent is too short and 21 years is too long, any more than the current price for a gallon of milk can be objectively classified as too low or too high. Again, have to think back to the Ethics of Liberty by Rothbard, because again, when it comes to this argument, okay, you homestead some piece of land. How long do you maintain ownership of this piece of land? And Rothbard really bites the bullet here and says, well, in perpetuity, as long as you can prove that you were the first to homestead that piece of land, you could be gone for 30 years or 50 years and come back. And if you can reasonably show that you were the first appropriator of that land, then you have some claim to it. Of course, if in the meantime somebody else moved in and did their improvements on the land, then you have to sort this thing out. But it's very clear in the mind of Rothbard that it doesn't expire. Like, property rights don't have an expiration date. Thus, one problem with the natural rights approach to validating IP is that it necessarily involves arbitrary distinctions with respect to what classes of creations deserve protection and concerning the length of the term of the protection. Of course, one way to avoid this difficulty is to claim that everything is protectable by IP, with perpetual terms, so into infinity. Spooner, for example, advocated perpetual rights for patent and copyright. Schulman advocates a much broader concept of creations or ideas protectable by IP. He argues for property rights called logo rights in any logos that one creates. The logos is the material identity or identity pattern of created things. The owner of a logos would own the order or pattern of information imposed upon or observed in material substances. The most radical of all IP proponents is Andrew Joseph Galambos, whose ideas, to the extent that I understand them, border on the absurd. Galambos believed that man has property rights in his own life, primordial property, and in all non-procreative derivatives of life, since the first derivatives of a man's life are his thoughts and ideas are primary property. Since action is based on primary property, actions are owned as well. This is referred to as liberty. Secondary derivatives, such as land, televisions, and other tangible goods, are produced by ideas and action. Thus, property rights in tangible items are relegated to lowly secondary status as compared with the primary status of property rights in ideas. Even Rand once elevated patents over mere property rights in tangible goods in her bizarre notion that patents are the heart and core of property rights. Can we really believe that there were no property rights respected before the 1800s, when patent rights became systematized? Galambos reportedly took this his own idea to ridiculous lengths, claiming a property right in his own ideas and requiring his students not to repeat them, dropping a nickel in a fund box every time he used the word liberty as royalty to the descendants of Thomas Paine, the alleged inventor of the word liberty, and changing his original name from Joseph Andrew Galambos Jr., presumably, to Andrew Joseph Galambos, to avoid infringing his identically named father's right to the same name. I mean, you gotta give it to him. He's consistent in his own ideas. But what I take away from this is, okay, instead of having physical property as the primary property and intellectual property kind of as a secondary derivative, this is flipped the other way around, in that ideas come first, so thoughts come first, actions come first, and then the tangible property is the secondary status. And this would then mean that, well, we couldn't really have physical or tangible property rights without having the intellectual property rights. By widening the scope of IP and by lengthening its duration to avoid making such arbitrary distinctions as Rand does, the absurdity and injustice caused by IP becomes even more pronounced, as Galambos demonstrates. And by extending the term of patents and copyrights to infinity, subsequent generations would be choked by ever-growing restraints on their own use of property. No one would be able to manufacture or even use a light bulb without getting permission from Edison's heirs. No one would even be able to build a house without getting permissions from the heirs of the first proto-human who left the caves and built a hut. No one could use a variety of life-saving techniques, chemicals, or treatments without obtaining permissions of various lucky, rich descendants. No one would be able to boil water to purify it, or pickling to preserve foods, unless he is granted license by the originators or their descendant heirs of such techniques. Such an unbounded ideal rights would pose a serious threat to tangible property rights and would threaten to overwhelm them. All use of tangible property would by now be impossible, as every conceivable use of property, every single action, would be bound to infringe upon one of the millions of past accreted IP rights, and the human race would die of starvation. But as Rand noted, men are not ghosts. We have spiritual aspects, but also a physical one. Any system that elevates rights in ideas to such an extreme that it overrides the rights in tangible things can clearly not be suitable ethical system for breathing human beings. No one living can actually act in accordance with such an unrestricted view of IP. The remaining advocates of IP all qualify their endorsements by limiting the scope and/or terms of IP rights, thus adopting the ethically arbitrary distinctions noted above. A deeper problem for the natural rights position lies in its undue emphasis on creation, instead of scarcity, as giving rise to property rights as discussed below. So this is where we will pick up in the next episode, when we will be talking about IP and property rights. But I think we had a pretty good overview so far of the libertarian perspectives on IP. So we learned that there is a wide array of ideas that circulate in the libertarian circles on how to justify intellectual property. There's the utilitarian approach, notably advocated by David Friedman, the son of Milton Friedman, and a great thinker in his own right, I would say. So I think his arguments are somewhat convincing, not as convincing in my opinion as Murray Rothbard, but still I think it's interesting to come from this utilitarian approach, because I think also you can justify, or liberty and libertarian philosophy and property rights do lead to a greater good for the whole of society, although I wouldn't use this as justification for them. So this is interesting. And we saw that the utilitarian argument for intellectual property rights really don't hold up, because we cannot compare utility among people. We would have to infringe on the property rights of some people to give property rights to somebody else. And thirdly, we cannot even make the distinctions between if it's a net benefit for society to have patents and copyrights to begin with. And then on the other hand, we tackled some of the natural rights approaches to defend property rights. We saw that Ayn Rand's distinctions are arbitrary and really nonsensical, and if followed to its logical conclusions, really end up in a world where we are bound and cannot decide anything. And this, again, I'm sorry I have to draw so many parallels to the ethics of liberty, but this again reminds me of it. In one of the earlier chapters, Rothbard explains communism as communism would normally be understood, namely that nobody is a self-owner in that they own their own body and make the choices for their own body, but that everybody owns a little bit of everybody else and themselves. But this would lead to a world where we can never act, because in order to act, we would have to get the consent of all of the other owners. So the human race would die out really quickly. And similarly here with the IP argument, that if there really was such a thing as intellectual property and the original creator of that idea or whatever, we would have to get permission from them. Similarly, the human race would also die out really quickly. And also, to me, it comes to language. Yeah. If we think about language, and I mean, I'm using words here invented by somebody else. I don't even know who. And if I were to get permission from I don't know who to make this podcast episode, you wouldn't hear this. It wouldn't have been made. So yeah, very interesting stuff. If you want to chime in on this conversation, you can try to join my secret matrix group. If you've helped unlock this episode, then you can claim your transaction and you will get an invitation link. I'll leave a link to this in the show notes for this episode. I'll also leave a link to Stefan Kinsella's website, the book, of course, if you want to read up all of the footnotes that I've skipped over here. And yeah, if you want to shoot me a little tip, you can do that on xmrchat.com/alexanarcho. There you can send me a message and send over some Monero. And then I would be really to see you again in the next episode, because now we are getting into the good stuff. Yeah. So far we have we are warmed up now. Yeah. We understand a little bit of intellectual property, what the different kinds of intellectual property are. We now saw some arguments for it and we saw some arguments against it. But I think now we are just about to really get into the meat of the entire thing. And, we don't have that much left. Yeah. So let me jump back to the beginning of the book. We are now in part 2, I would say. No, actually, we are just finished with part 2. So we have part 3 left, which is called IP and property rights. And then we have part 4, which is IP as contract. So yeah, the next one is going to be a really good one, because I think Kinsella is going to lay out what he considers the right position on intellectual property. And if everything you've heard so far is unsatisfactory to you, you really don't want to miss this one. So make sure to subscribe my podcast, and then I will see you in the next episode. Until then, have a good time.